Good morning. Welcome to this edition of Lessons from Litigators. Today's topic is 10 things you should know about business insurance. Andy, would you like to introduce yourself?
Yes, my name is Andy Portinga. I'm a litigator here at Miller Johnson. I've been with the firm for 24 years, and I am co-chair of the Insurance Recovery Practice Group.
And my name is Neil Marchand. I've been with Miller Johnson 11 years. I came here after clerking on the Western District of Michigan, and I am also the co-chair of the Insurance Recovery Practice Group. This morning, we're going to talk about 10 things you should know about your business insurance. Andy's going to kick us off with the difference between two types of policies.
So the first thing that you should know about business insurance is the difference between an occurrence-based and a claims-made policy. Consider the following scenario. In year one, there's an accident and somebody gets hurt. 2 years later, in year three, a lawsuit is filed arising out of that accident. Which policy year has to respond? Which policy has to cover that loss? Well, for an occurrence-based policy, you look at when the bodily injury occurred. For a claims-made policy, you look at when the claim was made. That's the key difference between occurrence-based and claims-made policy. Occurrence-based policies are triggered by the occurrence of bodily injury or injury, whereas a claims-made policy is triggered by the making of a claim regardless of when the injury or the accident occurred. This leads to the second thing you should know about business insurance, which is that you never, ever, ever throw away an occurrence-based policy. Why? Because there is gold in the old. In the 1940s and the 1950s and into the 60s and even beyond, asbestos was the gold standard for insulation. It was used throughout the country as an insulator. At the time, people didn't know about its harmful effects. Eventually, in the early 80s, it was pulled out of the market, and there were, of course, a lot of lawsuits filed by people who were harmed by asbestos. But when those lawsuits, the plaintiffs would allege that they were harmed by exposure that was often decades before the lawsuit was filed. For an occurrence-based policy, the lawsuits that had to respond to defend and cover those lawsuits were policies that were in place many, many decades before. That's because they looked at when the occurrence or when the bodily injury began, when the exposure began, as opposed to when the claim was made. Even now, asbestos has been off the market for about 40 years. There are still asbestos lawsuits being filed, and there are still insurance policies back from the 50s and 60s that are on the hook for those lawsuits. Another example is sexual abuse litigation. We're seeing an increase in sexual abuse claims now against the Catholic Church, the Boy Scouts, various universities and schools. And very often those claims are based on incidents that occurred years and sometimes decades before. Those defendants, those companies or those institutions are looking to their policies in place at the time of the occurrence, at the time of the alleged abuse for coverage. Sometimes we have clients come to us and they don't know who their insurer was back in 1985 or 1992, and that can be a problem. You should never, ever throw away an occurrence-based policy because none of us know what the mass tort of tomorrow is. But when that comes, you want to make sure that you have a record of what your coverage is and a copy of that policy.
Now, the third thing that you need to know about your business insurance is the scope of your insurance company's duty to defend you. So any insurance policy will have two different types of duties, a duty to defend and a duty to indemnify. The defense duty refers to the insurance company providing and paying for your attorney's fees and costs related to the litigation. The duty to indemnify relates to paying for any liability that you ultimately have out of that lawsuit. Here, the focus is that initial duty, the duty to defend, and whether the insurance company has to pay for an attorney for you. This is commonly referred to as litigation insurance because you're protecting yourself against the prospect of being sued. This is triggered when you have a claim that falls within a policy. So either within an occurrence policy or a claim made during the policy period for a claims made policy. And the insurer, the insurance company, has a duty to defend, pay defense costs, and for their insured, the person who bought the policy. This is where you may want to consider and look to whether you're an additional insured under someone else's policy. Oftentimes that's required and specified in different contracts that you may have with suppliers or customers. The importance of the duty to defend is that it's covering your attorney's fees, which can be significant. Oftentimes because the duty to defend applies even if the underlying claim is meritless. Even if there's no merit to it, you still have that, the insurance company still has that duty to defend. What's important also about the insurance company's duty to defend, it's not automatic. Andy's going to be talking about timely notice, and you have to provide that notice. Otherwise, you don't get this protection. But before we talk about notice, you need to know how the insurance company pays for that duty to defend and how it impacts your overall coverage. Some policies are called burning limits or wasting limits policies. And what does that mean? So a policy will say, we will pay for loss up to a per claim limit or a per occurrence limit of, let's say, $1 million. Then you look to the duty to defend. Some policies have a duty to defend where the attorney's fees are an additional kind of bucket of money the insurance company pays above and beyond that $1 million. Other policies are what we call burning limits or wasting limits. And that means you have $1 million for a claim or an occurrence, and the attorney's fees, the money spent to defend you in that case, reduces the amount of liability and coverage that you have left. So if your attorney spends $100,000 defending you in a case, your $1 million policy just went down to $900,000 to pay for any liability that's potentially covered by the policy. These policies, the burning limits policies, can be cheaper for you to purchase, but it's cheaper because you have less overall coverage. One thing to note in these types of policies is all hope may not be lost. Even if you have, these policies frequently have an additional coverage provision specifically for defense costs. So once the initial limit of liability has been paid, there may be additional coverage only for defense costs, not for an underlying liability. You'll see that type of situation in employment practices policies for wage and hour violations, also in professional services policies for various types of licensing violations and state administrative hearings.
The fifth thing that you should know about business insurance is the importance of giving timely notice. If you get a claim, if you get a lawsuit, or if you get a demand letter seeking monetary relief, monetary damages, give notice to your insurer right away. Don't wait. I am often surprised by clients that are unwilling to put their carrier on notice of a claim. Sometimes the clients will say, well, this is not going to be that big of a problem. Well, you don't always know that. Sometimes small problems grow into big problems. Sometimes clients say, well, my premiums will go up. Well, that may be true, but if you're not going to use your insurance, then why have it? You pay the premiums and you ought to use it when you have a claim. If you don't give timely notice of a claim, you're very likely to lose coverage. It's very important to give timely notice of a claim. The sixth thing we want to talk about is you should know who gets to choose counsel in the event that you are sued. in most situations, your carrier, your insurer, will get to choose your attorney for you. That is, the carrier has the right and duty to defend, and with that right, in most situations, the carrier gets to choose who is going to be representing you. That's not always true. There are some policies that give the policyholder, the insured, the right to choose counsel, and that's something that you can negotiate for. Also, there are certain situations where there may be a conflict of interest between the insurer and the policyholder, and in those situations, the policyholder can choose their own counsel in some states. And that arises when, for example, the insurer reserves its rights to deny coverage. The insurer may say, yes, we'll defend you in this claim, but we're not so sure we're going to cover it at the end of the day. In that situation, there may be a conflict of interest between the insurer and the policyholder. And in many states, that conflict gives the policyholder the right to choose their own counsel. That's not true in every state, though. In Michigan, the law is not that well developed on this issue, although there is some case law that even when there is a potential conflict of interest, the insurer still gets to choose counsel. So that's one thing to know about your coverage. When you have the duty to defend, you may not get to choose your counsel.
The next issue that you should know about your insurance is how the insurance company allocates loss. Well, let's first talk about what loss is. Policies will define loss frequently as defense costs and damages. The defense cost being what it costs to pay your attorney and to go to proceed with the litigation. Damages being the ultimate liability either through settlement or a judgment. And so the policies will have an allocation provision frequently in the general terms, and it's the policy will provide how loss, those defense costs and damages, are allocated. Who pays how much of what type of loss? This is important because even where the insurance company has the duty to defend you, it doesn't mean that the insurance company has to pay all of your defense costs or all of the underlying loss where they're agreeing to provide a duty to indemnify. For example, a policy may have an allocation provision that says all defense costs are allocated to covered loss and everything else is based on another formula. Or the policy may say, we're going to allocate defense costs based on the number of claims that are actually covered by the policy, or the number of parties sued, or how you arrange your underlying defense, or the amount sought from you versus the other parties in that case. Another variation is how long that insurance company was on the risk. Where you have an occurrence policy, let's say there's pollution over a 12-year period. You had one insurer for 9 of the 12 years, and that insurer will likely say, we only have to pay at a maximum 3/4, 75% of your defense costs, because out of the 12 years where that pollution was leaking into the ground, we only covered 3/4 of those years with our policy. And this is important to know how this loss is allocated because it goes to our next point. You have to expect the unexpected. And it is common to have disputes relating to an insurance company's duty to defend the policyholder and the insurance company's obligation to indemnify and provide coverage for an underlying loss. This doesn't mean that your broker or your agent did something wrong. It doesn't mean that your attorney did something wrong. What it means is that for the vast majority of companies, you're purchasing a standard form policy. There will be numbers at the bottom, and that standard form is trying to be applied to an infinite number of scenarios. And in each unique situation, the policy in the wording may lead to a different interpretation between your coverage counsel and the insurance company. That's quite common. So yes, you are purchasing insurance, and that doesn't mean there's a guarantee of coverage or that the litigation is not going to be stressful and that the insurance company is going to take care of everything. Litigation is inherently stressful. It's going to be stressful regardless. It also means that where you have more than one insurance carrier, it can often complicate the scenario, because when you have more than one policy that is triggered for a claim, you have other insurance provisions where each insurance company will say, if another policy is triggered, we only paid this much. And those provisions may conflict. So then the policyholder and the insurance companies have to figure out who pays how much of what. The allocation provision also comes into play. And so multiple insurance companies can frequently complicate coverage for an individual claim. So this is why, and as we'll hit on later, it's important to know what you're getting in your policy and the type of coverage that you have, because the unexpected frequently happens when a claim arises.
So the ninth thing I want to talk about is the underwriting and renewal process. And we're talking about the process of applying for coverage or renewing existing coverage. It is extremely important when you apply for coverage or when you're renewing coverage to be accurate in your application. The application will ask you for information regarding known claims. And if you make a material misrepresentation in your application, you are likely to have your policy, a claim denied, or possibly your policy rescinded. An analogy to a non-business context would be in life insurance. Sometimes people will apply for life insurance and they'll be asked, are you a smoker or have you ever smoked? And the applicant will say, well, if I say I'm not a smoker, then I get a lower premium. And they'll say they're not a smoker. And then something happens and the insurer finds out that the person was a smoker. Doesn't matter if the cause of death was related to smoking or not. The insurer will say, you made a misrepresentation in your application. It was a material misrepresentation, and therefore there's no coverage. It is very important when you apply for coverage or when you renew coverage to be accurate in your application.
You want to get the coverage that you want. Frequently, we hear from clients, well, I thought that was covered under our policy, or this should be covered. It's the policyholder's obligation to know about their coverage. How can you do that? There's two things that we recommend. First, work with an independent insurance agent or a broker to get coverage for your business. And we reference the independent insurance agent or the broker because those individuals and entities work for you. A captive insurance agent, on the other hand, works for a specific insurance company. So the broker and the independent agent is going to be able to know and determine your risk and go out into the market and find the best coverage for you. The second thing that you can do is ask your attorney about coverage. And this isn't a one-time, one-off situation. Attorneys can help you identify the risk that you have in your business and when that risk occurs. For example, you pick up goods to install at a customer's job site, and you pick those goods up in New York. Did you assume the risk for any loss during transportation from New York to the job site? Potentially under the contract. And now, does your insurance policy cover that property in transit, even if it's not your property? That's a risk that you need to know. And you can negotiate, and knowing those risks on the front end can help you negotiate that contract with the seller of the goods, with your customer, and with your insurance company, so that you have the level of risk and are comfortable with the level of risk that you've assumed and the coverage that you have. The other thing to know is various other types of insurance. You may have a cybersecurity risk if you're a medical provider. You may be able to get coverage under someone else's policy simply by asking for it in your contract with them, by being named an additional insured. And, or in addition to, there's other types of coverage. So you have a primary layer. Maybe you want an umbrella coverage. If you're covered under someone else's policy, maybe you want an extra level of coverage that's cheaper, umbrella, because it applies over the top of another policy. These are all options that you can have, but you can't have them unless you ask and you know about them. So ask questions and get the coverage that you want so that you don't have the unexpected later.
Thank you all. Our next webinar is Thursday, December 16th. The topic is managing a business in crisis. Neil and I thank you very much for your time.
If you have questions, feel free to reach out. Thank you for your time and for joining us this morning. We hope you have a great day.
Thank you.